Representative Moody, would you please describe the difference between an affirmative defense and an exception to prosecution?
Well, for those people following at home, they can read Penal Code 2.04 or Penal Code 2.02. For those people here in the chamber that are listening attentively, because this policy actually matters, I will tell you this. The affirmative defense means that someone who is charged with a crime is not going to escape arrest, jailing, charging, or trial. They are going to have to bring those pieces of evidence forward and prove them through evidence in trial, and then have them submitted to the jury, and then prove them beyond a reasonable doubt. And in this case, what we're talking about, because these already exist in the bill, we're talking about scenarios in which someone is lawfully present in the country, not illegal, someone who is lawfully here. And we're saying, we'll give you the big favor of proving this up at trial.
And Representative Moody, doesn't this affirmative defense actually suppose that this individual can afford an attorney, competent counsel, and or is appointed counsel who is aware of this statute?
Look, for those of us who take our duty seriously, whether they're hired or appointed cases, you'd hope that you would look through these things and make sure that you're doing your job correctly. My point is, if someone has followed all the rules and the federal government has granted, I'm reading this right out of the bill, the federal government has granted the defendant lawful presence in the United States or asylum, or that their conduct doesn't constitute a violation of federal law, or that they've been given benefits under DACA. I'm just saying, why in the world would we put the onus on the person who has followed the law to go all the way through to trial to prove to a jury beyond reasonable doubt that they're here lawfully, when at the front end, the prosecutor has all this information at their disposal? And if these facts aren't present, then plead it. Put it in your pleadings. This person hasn't been granted, they haven't been granted lawful presence in this country. They haven't been granted asylum. They haven't shown that they didn't violate federal law in coming into this country. They haven't been granted DACA benefits. Those are all verifiable facts that the prosecutor has at their disposal. So before we go forward with the trial, before we go in front of a jury, just do the homework. And if all these things exist, if any of these things exist, that's an exception to prosecution, which means you can't charge the case.
And Representative Moody, I think your amendment is particularly important in light of subsection F in this bill, which could conceivably confuse courts and counselors alike, in that subsection F states, a court may not abate the prosecution of an offense under this section on the basis that a federal determination regarding the immigration status is pending. So under that directly conflicting statute in the bill, isn't it possible that there could be a scenario where an individual meets his or her burden and affirmatively proves up their defense, and yet the court will find themselves in a conundrum stating, "But even though you did that, I can't abate this proceeding, absent your amendment"?
No, I think the abatement provision exacerbates the problem, because the point here, and the reason why the abatement provision's here, is we want to rush forward with these state-level prosecutions. We want to move them as fast as humanly possible. And the problem that is going to present is someone could be here lawfully, could have an asylum case that is vindicated, could have any one of these benefits, but because we're not going to allow the court to say, hey, let's just hold on to see what's going on, maybe they do have federal lawful presence, the way that F interplays with this section, we're just going to run right through the system. And so my point is, there's no harm in doing this analysis up front. Here's the thing, it actually doesn't stop someone from being arrested. Doesn't it stop someone from being jailed? Potentially, and hopefully, if they are lawfully present, they won't be charged with this crime.
So they're still going to ride the ride, so to speak.
Yeah, I mean, unfortunately, there's no real way to ferret this out before jailing. And so someone who's accused of this or is suspected of this is still going to be arrested. They're still going to be jailed. But at the time that a prosecutor is going to look at this case and evaluate it, they would have the burden on them. And we talk about this. We've talked about burdens in here all the time and how important they are, right? And how we need to take our time with decisions.
Representative Moody, thank you so much for this amendment. I believe it clears up any ambiguity and conundrums that will be placed on the courts across the state of Texas with subsection F, and for shifting the burden of proof back to where it should be, which is on the state.
I appreciate that. I just think it is to me.
Gentleman's time has expired.